Good morning, everybody. The time is 9 o'clock. My name is Christian Waugh, and I'm going to call this Citrus County Code Compliance hearing to order. The first order of business is I'd like to ask you to join me in standing for the pledge to the flag. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
So for these hearings, we have agendas, and the next item that's listed on the agenda is dealing with the minutes from the January 19, 2022 hearing. There was no February hearing. Are there any objections or proposed revisions to the minutes as currently formulated? Hearing none, I'll approve the minutes.
Staff update, the abated cases are posted out front. We don't have any continued cases.
All right, thank you. Everyone else, good morning. Again, my name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by the law, but all that it means is that Citrus County has hired me to preside over your hearing. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I will state the alleged violation and allow the county to present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence if you wish. I also want you to know for the record that these hearings are recorded and then uploaded to YouTube. During this process, the county attorney's office or myself may have questions of parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and be made as succinctly as possible. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate or fix the violation by that date, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to impose that fine as a lien on all of your real or personal property, and the county may foreclose on the lien or seek money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with the county code. The county will continue with its liens against your property until you notify the county of your compliance. In all cases in which I find someone guilty of a violation, I will impose all costs required by the county ordinance or regulations. If you fix the violation in the time you're given, that cost will remain minimal. If you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of a violation and allow for a continuance of your case, you will be required to return on another date. In the time between hearings, I will require that you comply with the county and its codes in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each day of the violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. Are there any cases for demolition or, okay. Ladies and gentlemen, you do have the right to appeal any order I make today as provided by law. Thank you.
All right, the first case today, Robert H. Speakman, case number 2149020. Code Officers J.C. Charlton, page 28 of your agenda.
Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name for the record, sir.
Gary Speakman.
Thank you, sir.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 214-9020. Mandatory sewers connection. It's a violation of Chapter 42, Article 5, Section 42163A of the Citrus County Code of Ordinances. The address, 1167 North Rice Terrace, Crystal River, Florida. Property owner, Robert H. Speakman. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, a notice of requirements to connect a central public sewer system within 365 days and a 90-day connection notice. Exhibit B, the notice of violation, notice of hearing, and a copy of the continuance letter notifying the property owner of today's hearing.
Sir, I'd like to ask you if you can review the documents he has
Okay.
and let me know if you have any objection to them being evidence in this hearing as what's been proposed as Exhibits A and B.
Okay. That's his signature. Yeah, you good with that one? That's that?
Sir, do you have any objections to these documents being
No.
evidence?
No.
Is there anyone from the public who's going to want to be heard on this case? Okay.
We do have a representative from the city of Crystal River.
Okay, great.
It wouldn't be public, it'd be part of the
I
county's
assume.
case.
Yeah, thanks. Thanks. Without objection, what's been proposed as Exhibits A and B are evidence.
I received this case on August 23rd of 2021 and found that there was no permit to connect to the public sewer system. I've been in contact with the City of Crystal River's Finance Department, and they have also informed me that there's been no connection. At this time, the property continues to remain in violation. No permit applied for connection.
Is there anyone else who wishes to testify on the county's behalf?
Yes, I have City of Crystal River Finance Director Michelle Russell.
Good morning, Ms. Russell. What would you like to put into the record?
I would just like to kind of give a recap of the notification that's been
Sure.
Submitted.
I see your name in Exhibit A.
Michelle K. Russell Maynard, Finance Director for City of Crystal River. Back on July 23rd, 2014, we issued the first 365-day letter to Robert Speakman, which is Gary Speakman's father. It was sent certified mail, and the return receipt was signed and returned to the city dated August 1st, 2014. Then a 90-day letter was sent on May 18th of 2015 as well to Robert Speakman. And then in March of 2017, we confirmed basically on the property appraiser site that he was still the owner of the property, Robert Speakman. We went through the process again. We issued another 365-day letter per discussion and meetings with the county that was recommended. We sent the second 365-day letter dated February 4th, 2021 to Robert Speakman. That was returned unclaimed on February 26th, 2021. On August 6th, 2021, we confirmed that the property had still not connected, and the city provided documentation to the county showing the return receipt, and then the county issued the notice of violation. On December 13th, 2021, I received a phone call from Mr. Gary Speakman, which again, he's the son of Robert Speakman. He informed me that his father had deceased on May 1st, 2020, and that he was the executor of the estate and was handling it. He said the property was in probate, and that the wife was contesting it, and that he was going to court in January 2022. And so he was asking to see if the hearing that was scheduled for December 15th could be continued. It was agreed that the hearing was canceled and rescheduled for today. On March 8th, I received another phone call from Gary. He and I spoke in regards to the hearing for today. He was asking for another continuance because the executor final hearing is scheduled for July 7th. He is proposing that he wants to demo the home. He really doesn't want to have to do a connection twice. I spoke with the city manager about it. He did not desire to postpone it any longer. He explained to me that there's a tie-in location as a function of the design of a new house and can easily be shown on the plans in the same location. So he suggested that Mr. Speakman follow through, attend today's meeting, and go before you.
So what does that mean with the tie-in? Basically that it doesn't matter whether there's a new construction on the property or not from the city's perspective?
My understanding, and I'm not construction, I apologize. My understanding is it doesn't really matter where it comes in.
Where it ties into the system?
Yes, sir.
Okay.
Sorry.
But it would on the structure of the home, then you'd have to put
We'll
the-
talk about it. I don't, you know, in my own experience, it may or it may not. So I think that's interesting. Okay. Is there anything else that you'd like to offer into the record?
The other thing is he's talking about demoing the property. If that is in fact his desire, he could come in to the building department and pull a demo permit now. That usually takes 6 months anyway, so it would fall after his time frame of the July 7th meeting that he has scheduled.
I'm not sure if he can. We'll talk about the probate issues. I'm trying to think this through. Why did it take so long from 2014? I mean,
Well-
this is 8 years.
Right. There was a lot of changes with staff. We were still learning all the processes, and so it was recommended that we just start the process all over again.
And I haven't seen this code section before, so I'll probably take a minute or two to read it. Mr. Speakman, I want to hear your version of what's happened.
Yeah, so my father did not connect it. I think what was at issue with my father was that the property sits on what he believed to be a private road from when he purchased the property, and I have the survey from when he purchased the property. So Rice Terrace is shown in the public record as extending in front of his property, but if that's a county road, it's never been maintained by the county, and it shows here as Boathouse Drive. So I think that's why he didn't do it. I'm not opposed to doing it, but I don't know if, it's like I said, I told the city, hey, I'll pay the, there's a connection fee I think that needs to be paid, but I just don't want to have to run the plumbing, because the mobile home that sits on there, I doubt where I would build the house that would connect into the plumbing that's in the back of the house. There's only, one toilet and shower in the back of the trailer. It's not on Ozella water. It's on a well, and that has to be changed as well. So
Is there someone living there right now?
no.
Okay. What's going on with the probate?
So there was a.
You're the personal representative?
I am the personal representative of the estate. The homestead was contested because he owns a home in Crystal River, and he owns a home in Daytona. But that ruling came down late January.
Did you petition for homestead on one of those properties?
Yes, it was basically a determination of what was his actual homestead
Right.
on death versus his ad valorem homestead. So he had ad valorem in Crystal River, but he had a separate home that he maintained in Daytona.
Which
so
one had a higher value?
The one in Crystal River.
Okay.
But for estate purposes, it was ruled that his home was Daytona. So that stopped any property. I couldn't do anything with any of the
And
property.
he had a spouse at the time that he passed away?
He did.
Did he have a will?
He did.
So what's being contested in the probate besides the
Which home was the homestead?
Why was that being contested?
because she had a premarital agreement that said she gets 100% of the home in Crystal River,
Okay,
and she tried to attach Homestead to that, meaning she would get 50% of the home in Daytona. But if his homestead's in Daytona, that comes out of
Correct.
the estate.
Correct.
And that's what the judge ruled.
interesting.
Yeah.
So what's going on in July? That you
That's
need-
just when the probate case is we petitioned to extend resolving the probate to be able to sell properties and
Oh, okay.
yeah,
Oh,
so the
okay.
probate's still going on. July.
But there's no contested issue. You just want enough
now
time.
now we've resolved that. Yeah, that was before there was kind of a two-part conversation.
Okay, so you actually do have authority now, basically, to do. I mean, are you the only beneficiary?
No, she's a beneficiary, and so is my nephew.
Who's entitled to ownership of this property?
Well, she's only entitled to cash, and it's property's been in our family for 50 years, so I don't plan on selling it. Right, that's the issue.
Well, it's in the estate right now. So what I'm getting at is, who is it ultimately going to be distributed to?
My nephew and myself.
Okay,
Yeah.
all right.
Yeah.
Let me actually read this code section. So I'm just kind of piecing it all together here. I have a question for the county. So in Exhibit A, there's a notice of requirement to connect within 365 days, issued July 2014. That seems to comport with Section 42-164 Sub 1A. And then there's a second notice, which is a notice of requirement to connect to the public sewer system within 90 days. Is there a difference, or is there a reason why it went from 365 to 90? I'm trying to understand.
What we normally do is there's a whole year full of letters. There's normally a 365, I believe there's a 270, a 90, and then
I
there's
see.
a 30.
So it's just putting them
It's a-
on notice that the clock is ticking?
Yes,
Okay.
yes, sir.
Has the city had any conversations with the owner about potential connection exemptions?
Exemptions, no, not that
Okay.
I haven't.
Right. They exist. I just didn't know if there were conversations that
Okay.
you'd had. What's the county's recommendation? I'm just curious.
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask that ask the special master of this to find that the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
Mr. Speakman, let's assume that you and your nephew receive ownership of this property in July. Let's
Yeah.
just assume it. You probably could do it even earlier. I know how probates work, but regardless, how much time would you need to figure out what you're putting on the property, what that would look like, the plans, that kind of thing?
I think I will know probably within a month of that what we plan to do. Whether we think we can renovate it. It's kind of moldy and holes in the roof, and so we've got to determine. It's got sentimental value. It's where I grew up.
Okay.
So, if we can restore it, we'll restore it. But if we can't, then that's why I was just wanting to try and get a little bit of time to make that decision.
Right.
That's all.
Well, the case has been pending for 8 years, so I'm not sure time is necessarily of the essence unless the city tells me otherwise. In other words, does the city have an interest or a health concern that this be done in the next 2 or 3 months?
I'm sorry, I'm gonna have to
Okay.
have you speak with the Assistant City Manager, Mr. Dumas.
You were sworn in, sir. Yeah.
Yes, Brown Dumas III, yes, I was sworn. There's no immediate issues, however, I will tell you, yes, the city has dropped the ball and not dealt with this on a timely basis. We apologize that we're wielding the hammer at this point. That's not our intention. What we really want is compliance. This particular building is, or home is, within yards of the Crystal River. And, we have, that this system was a septic to sewer program. It is for the benefit not only of the individual homeowner, but it is for the benefit of the community as a whole. So, yes, we would like to move forward with this process, but the timing, we want to be reasonable in nature in that process.
Well,
So,
it's well known that, Crystal River is a growing city and it's had a lot going on, so I'm not criticizing the city. I'm just pointing out the
No problem.
timing of it. What I'm going to do is I am going to find that as a technical matter there is a violation. But what I'm going to do is, it's March. I'm going to say that the property owner is granted 9 months from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners as they are determined to be. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. So as an academic point, title, when someone passes away, is supposed to vest immediately in the heirs. A probate is a process by which it's achieved. So when I say that it accrues to the owners, it may only be determined by a court, but this order attaches to whoever the owners are today because it vests, if that makes sense.
Yeah, that's fine. Yeah.
All right, thank you.
Thank you.
Okay,
Thank
thank
you.
you.
The next case today, Jason T. and Chelan L. Money. Case number 242914, Code Officers J.C. Charlton, page 23 of your agenda. The expert in this case is going to be Miss Deborah Burns.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Can you please state your name, sir?
Jason Thomas Money.
Thank you.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 242914, conflict with Central Water Facilities, a violation of Chapter 42, Article 2, Section 4239B of the Citrus County Code of Ordinances. This case was granted a continuance at the January 19th 22 hearing for today's hearing. The address is 791 North Duncanfield Avenue, Crystal River, Florida. Property owners Jason T. Money and Shellen L. Money. Checked this morning for a permit to connect, and as of now, there's still, no permit to connect, or they haven't connected at this time.
I vaguely remember this, so it's my recollection, please correct me if I'm wrong, that we talked about, sir, possibly investigating obtaining a waiver
Yes, sir.
from the
And-
county for the requirement.
Yes, sir. So the initial was, we got a continuance for 60 days when I was here last, because kind of like the last gentleman, it was probate. Probate finally settled.
Right.
Right. So trying to find a plumber was hard. I called just about everybody in the county. Finally got Don's Plumbing to explain to me what the pressure drop would be. Well, even the length is not going to be significant enough. The other option is a medical waiver. That's where my hiccup is now. Being retired Navy, when I transferred, my medical records went with me. My family's didn't. So the first thing I had to do was request from NAS Whiting Field, which was my last duty station, but that only covered the time frame that we were stationed there. So now I'm waiting on records from NAS Jacksonville, which was where we were at before. As of this morning, it's been sitting on the guy's desk for 2 weeks. They finally got in contact with the person, and that's where we're at. So I'm waiting on the medical record so I can get a waiver, a doctor's note.
Okay, and so let me just review so that I can refamiliarize myself with how this code section works. Well, actually, first let me ask the county, have you been in discussion? Are you aware of this situation?
Yes, I spoke with him last week.
Okay. Assuming the records he's discussing are provided, is this something the county would consider? Because I don't know.
If there is medical issues to treated water, then that letter, it has to come from a doctor. On their letterhead, it goes to the environmental health director, and he'll give a waiver or a yay or nay.
In other words, the provision of the records would be insufficient. The county would want a letter from someone who's reviewed the records explaining.
Correct.
Right.
Okay. Do you have a doctor who would be able to do that?
Our primary care physician, and so just a little background, when we lived in Jacksonville, we were on city water, and my family all had issues with eczema and allergies because of the treated water. When we moved to Pensacola, and really didn't put this together until recently, when we moved to Pensacola, we were on well water, and well water here, and all that time, the 10 years we lived in Pensacola, we had no issues. So I'm just waiting on the records. My doctor's waiting on the records.
I reviewed some of the January hearing in preparation for today, and I put something on the record there that I hate continuances and kicking the can on things. But
Yes, sir.
given that it's a health concern, I think I'm probably willing to do it. But how much time?
30 days. I was told this morning that the record should be here today.
All right. Well, I'm going to continue it to the next hearing and not make any findings today.
Okay.
Okay.
Can get something on the record if possible. If within the 30 days a waiver or the exemption is granted, is there a need in your eyes to bring it back before you?
No.
Okay, I just want.
If there's an exemption under the code section, unless someone tells me otherwise, is I don't think I can find.
Right.
a
I just
violation.
didn't want to have to bring
Oh,
everybody
yeah, I would
back
take it off
together
the-
if it.
I would
okay.
take it off. Yeah, if that happens.
Correct.
Right.
I'm with you. I just wanted that clarified.
Thank you. Thanks.
Thank you.
Awesome. Thank you.
All right, the next case, Kyle D. Breeden and Mallory R. Breeden, case number 214-4283, code officers J.C. Charlton. Page 6 of your agenda, Ms. Joanna Coutu is going to be the expert on the case.
Mr. Breeden? Do
Yes,
you
ma'am.
swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please, for the record.
Kyle Don Breeden.
Thank you.
Thank you.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 2144283, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. This case was granted a continuance at January 19th, 2022 hearing for today's hearing. The address is 8646 West Admiral Byrd Lane in Crystal River, Florida. Property owners Mallory R. and Kyle D. Breeden. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on January 29th, 2021. Follow-up inspections on August 3rd, August 30th, October 6th, 2021, and January 18th of 2022, and my final inspection on March 15th of 2022. Exhibit B, a copy of the notice of violation, notice of hearing, and a copy of the continuance letter, and a copy of the property appraiser's report.
Before we get into that, one of the issues, this is the hearing I went back in January to look at. It looked like one of the reasons why I continued it is that I wasn't prepared to assess the legal sources. There were attorney general opinions provided. There were some statutes. I did make a finding that it wasn't agricultural zoning. That is out the window. But I still am concerned about the application of those laws. And is the county able to talk to me about how those laws apply today?
Which law?
So, sir, if I could, I left Joanna a voicemail on Monday. I've talked to JC. I've talked to half a dozen folks in Citrus County. The code compliance, and I don't want to speak for anyone, but the neighbors are happy. Who I talked to in Citrus County doesn't see this to be an issue. Again, I went in, I cut down a whole bunch of trees. I had stuff, palmettos, not trees, but I had stuff piled up everywhere, had trailers all over the place, and a neighbor called and the county freaked out. They're like, oh my gosh, what is this guy doing? He's making a storage lot here, right by our economic growth facility, and so, but what the issue is, an individual in office within Citrus County does not believe that the Citrus County attorney's legal opinion on record to be a fact, and that agricultural structures do not require a building permit. And that's kind of where I see the biggest hindrance here.
I don't think that's the issue before me today, is whether there's a building permit that's required, unless I'm wrong. That's not at all before us.
So my understanding is, what I'm getting is code compliance cannot drop this issue because land development says that there has to be a permit for the structures that are on the property.
This is why, if you don't mind, Mr. Braden, this is why I asked my question first. So is the county able to brief on the laws that were brought up at the last, there was
on the Farming Act?
Yeah.
We don't believe it applies here because we're allowed to enforce our zoning code, which was enacted prior to his establishment of any agricultural use, which hasn't, and he also doesn't have the agricultural classification. But
so I come back to the property is.
Hold on, sir. If we allow each other to speak without interruption, that'll work best. So it's the county's position that the statute that was provided, I think it was a Florida statute.
The Right to Farm Act.
The Right to Farm Act doesn't apply. It doesn't override the zoning code in any way.
Not in this case, because this farming activity, which he claims is farming activity, and it hasn't been established that it's farming activity, it did not predate the adoption of the code.
Okay, you're saying if it did predate the adoption of the code,
then we could have an issue.
Well,
but this was something that was just started within the past year.
I think one of the points he raised at the last hearing that I thought was interesting was that, according to him, the only way to achieve to get the protection is to actually perform some agricultural acts on the property, if I'm not mistaken. So it's kind of a catch-22. If it's illegal to do the agriculture beforehand, how can you ever get protection of the Right to Farm Act? Am I misstating your position, Mr. Breeden?
Not at all, sir. That's correct.
Well, the Right to Farm Act was established to protect existing agricultural operations from being considered as nuisances to the surrounding properties. This property was vacant land. It wasn't a nuisance to anybody. It wasn't an agricultural operation that new neighbors could complain about. He brought it in, and it's also not been established that it's a bona fide agricultural operation. I believe he's got a couple ponies there and some
It's
chickens,
some goats and chickens.
goats and chickens.
Well, here's here's my problem. Normally, I have a code section that's here, and we're all pretty familiar with it. When I read the opinions that were provided to me, I was sufficiently concerned that I didn't fully understand the issues, and so maybe I think we continued it in part to see if you achieved the agricultural exemption by March. I'm not sure that's the only issue, and Ms. Antrim, I mean, if what you're saying is true, that would make this open and shut. But I don't have those authorities, and I'm concerned that I don't understand the issues. So, I mean, to be candid, again, I loathe doing this, but I'd really rather continue the hearing another month and order that briefing be given to me, because I don't understand how this law applies, and I'm concerned that it does.
Sir, I would also ask, I included for you the Rural Stewardship Act. So the area this property is in is Arrow Estates. It is a rural stewardship area that was established in the 50s. Agricultural is a granted use, and in my property's current zoning, it is zoned rural. That is a granted use, agricultural. That Stewardship Area Act predates the new law, and this area, the county has already determined that this portion of it is going to stay rural. They don't want to develop it.
Well, here's the thing. Based on what Ms. Antrim just told me, I feel like I understand her argument, but I haven't read the law in that context, which I would need to do, and we'd be here for an hour, hour and a half as I do it. So, but what I want to say is, if she's right, and if the county's right about this, then what you just argued won't matter. And the reason why is because the county has zoning, it applies to your property, it is residential zoning, it's not agricultural. So the use and the other things that you're able to do on the property are frankly irrelevant because of the zoning on the property. And if you were right about that act, someone would have had to challenge the zoning a long time ago, and they
No,
haven't
sir,
done it.
what I'm saying is, the act aside, the property is currently zoned by the county, was zoned when I purchased it, rural. Agricultural
No.
use.
No, sir. It's so I see what you're saying, but there's different. What we usually talk about with zoning is there are different categories. There's commercial, residential, industrial, blah 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 blah. It says rural in there, but it is a residential zoning.
Rural residential.
So
Yes, sir, what I'm saying is, what I highlighted for them is in rural residential zoning, as zoned,
right,
it provides permitted uses
right,
and secondary uses.
correct.
A permitted use in the zoning that my property is zoned, it says agriculture. That's what I'm saying, it
Yes.
says permitted, not secondary, permitted.
Okay, so here's what I guess I'd like is, I don't know if I've ever done this before, but I would humbly request that the parties brief me on two things for the April hearing. One is the applicability or the non-applicability of the Right to Farm or Farm Act. And the second is the extent to which a permitted use of agriculture would protect Mr. Breeden's use or not protect Mr. Breeden's use. And I just appreciate that, because otherwise I'm flying blind.
What was the second one? Extent to which?
The extent to which the permitted use in rural residential
Okay.
of, I guess, agriculture, I don't have it in front of me, but to which that may protect Mr. Breeden's activities. Mr. and is it Mrs. Breeden?
Yes, sir.
Okay, Mr. and Mrs. Breeden's activities, or not protected. And I'd really appreciate that. So otherwise, I'll continue the hearing to April.
Done.
Thank
All right,
you.
Thank you.
Yes, sir, thank you.
The next case, Mark Anthony Falligan, Brandy Nicole Falligan, case number 215-4483, Code Officers George Pearson, page 10 of your agenda. Ms. Joanna Coutu is going to be the expert.
Because, Ms. Antrim, you probably didn't have enough to do. And I've,
Oh, no,
you know.
I just had an appeal all the way to the 5th District Court on this issue.
Oh, you did sound very well informed about it. So,
truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Good morning, Mr. Pearson.
Good morning, sir. You ready?
Yes.
The case number, I'm first off, for the record, I'm a Citrus County Code Compliance Officer. The case number is 215-4483, violation of storage on a vacant property, a violation of Citrus County Code Land Development 3102A. The address is 2453 North Jungle Camp Road. One second, let me get my right glasses on. Inverness, Florida 34453. The property owner is Mark Anthony and Nicole Solomon. The service was good through posting of the property and posting of the bulletin board out in front that's dedicated to such postings. I'd like to authenticate and request the following be entered into evidence. Exhibit A, photographs that I took on November 18th, 2021. Photographs depict a violation of storage on a vacant property. Exhibit B, copies of notice of violation, notice of hearing, affidavit of posting, and property appraiser's report. Exhibit C, photographs that I took yesterday on March 15, 2022. The property was still in violation.
What were the exhibits again, Mr. Pearson? A, B,
And C.
and C. Okay, thanks.
Yes, C was a follow-up to make sure to see if it was in violation or not.
Is there anyone in the public who is here for this case?
Thank you, George.
Okay.
Is this one we talked about yesterday?
They're basically the same thing.
Without objection, what's been proposed as exhibits A, B, and C are evidence. Thank you.
I conducted an initial inspection on November 18, 2021. Violation of storage on a vacant parcel was observed. Travel trailer, utility shed, tent, and miscellaneous items were on the property. Attempts to contact the owner have been unsuccessful. On December 23, 2021, a notice of violation was issued. On February 3, 2022, a notice of hearing was issued, and I conducted an inspection on March 15th, yesterday, and the violation was still present on the property.
Is there anyone else from the county who wishes to testify?
I'd like to introduce to you Director of the Citrus County
Hello,
Code
nice to
Compliance Division, Joanna Cattell.
I'm definitely not Director of Code Compliance. Don't make me do that.
Oh,
Joanna Cattell, Land Development Director. This is a CLR MH zoning, Coastal Lakes Residential with a mobile home allowed. It is currently vacant. There is no primary structure, excuse me.
Okay, all right. So a mobile home would be a principal structure?
Mobile home would be, yes, if they put one there.
And that's not a mobile home, that's a
no, it's a travel
trailer.
trailer. sir.
Correct.
Okay. Just indulge me for a minute. What's the difference between this kind of a trailer and a mobile home? Oh, it's probably independently powered, or what?
It's considered as a recreational vehicle.
Right, right. It's how they're designed. Their Florida Building Code defines what a mobile home is. This is not designed that way. So
I guess I'm just trying to figure out what it is. I mean, I see a door, I see windows.
yeah, it's not a. It looks like a duck, quacks like a duck. It's actually how it's engineered and designed, and RVs are licensed, and there's different criteria. I don't know so much that you can tell by looking, at least for a layman like me.
Well, I think that's actually important to
Yeah.
determine that there isn't a mobile home on the property.
Right, and
so
it-
that's why I'm trying to understand.
Right, and in this particular case, the building division is clear that that's not a mobile
Okay.
home with their criteria.
One other thing, sir, I've tried from the very beginning of this case, which has been a long time, to make contact with the people, including going up and knocking on the door, and I've had no success. And there is obviously the notice of door hangers and notice of violations that I've left there, notice of hearings that I've left there. They know what's going on.
I hate to ask this. By the way, I'm going to find that there's a violation, but is there a definition of mobile home in the code somewhere?
In the definition section, you'll see manufactured home, which is a mobile home.
I'm sorry, where is it?
Definition section, chapter 1.
Chapter
under
1.
Manufactured.
Because it looks to me like it's a trailer, it would have to be towed, it's not under its own power or anything like that. So in chapter 1, there's a definition section, it's 1500.
Right.
And I don't see it in there.
A million times maybe it's something.
Do you want me to turn it around for you? Oh, well. Okay. So it's a manufactured home would be permitted.
Correct, which is a mobile home.
I see.
By
Okay.
common name.
Okay, let me check this out. Okay, all right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. The amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I am going to adopt the county's proposed findings of fact. The property is found to be in violation. The property is granted, the owners are granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a fine of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the Falligans. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also end up as a lien of record.
Thank you, sir.
Thanks.
The next case, Homosassa Preserve Llc, case number 214-4316, Code Officers Matt Hampton, page 13 of your agenda. Ms. Joanna Katu will be the expert on the case.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am, I do.
Good morning.
Good morning. How are you, sir?
Good.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 214-4316. Special requirements for all accessory structures. Violation of Citrus County Land Development Code 3102A. The address is 11265 West Spring Park Court, Homosassa, Florida. Property owner is Homosassa Preserve Llc. I have good service via posting of the property in the Lecanto Government Building. I would like to authenticate the documents and request it to be admitted into evidence. Exhibit A is photos I took during my initial inspection, June 30th, 2021. Photos taken on a subsequent inspection, November 17th, 2021. Photos I took on my corrective action inspection, January 5th, 2022. And photos I took during my final inspection, March 15th, 2022. Exhibit B is a copy of the property appraiser's report showing a vacant lot, a copy of the notice of violations sent out, a copy of the notice of hearing sent out, and a copy of the posting affidavit and a picture of the posting completed on March 3rd, 2022.
That's all in Exhibit B.
Yes, sir.
Is there anyone from the public who's here on this case? objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection June 30th, 2021, and observed on the property be in violation of land development code listed above. The property is a vacant parcel and has a fifth wheel travel trailer being stored on the property. I've conducted a follow-up inspection November 17th, 2022, and observed no change. The NOV, our notice of violation, was issued on December 1st, 2021. And let me go back. That follow-up inspection was November 17th, 2021. Observed no change. The notice of violation was issued December 1st, 2021, and I conducted my corrective action inspection on January 5th, 2022. There has been no change. I have had contact multiple times with the property owner, Mr. Brandon Algren. Notice hearing was issued February 15th, 2022, and as of my final inspection, March 15th, 2022, the travel trailer remains on the property.
And I assume you mentioned the owner, but it says Homosassa Preserve Llc. Is he the principal?
Yes, if you look we utilize Sunbiz for any kind of corporations, and he's listed as the registered agent. And the notice of violations, if you look at the rest, when we send them out, we send it out to the registered agent, and the registered agent is shown as to be Brandon Algren.
Is the Sunbiz in here?
No, sir, I did
That's
not.
okay. It doesn't really matter just because someone's a registered agent doesn't mean they're an owner. Did he represent that he
Yes.
owns the company? Okay.
Yes.
What did he say about the violations?
He was wondering what the issue was, and I told him that the property is vacant. He can't store anything on the property. And he said, well, it's a good-looking fifth wheel. I don't know why it can't be there. And I said, well, people around complained about it, so that's why I'm calling. My last conversation with him was that he was attempting to get it off the property, but wouldn't be able to do it prior to the hearing. He claimed that he was going to be able to have it within a week afterwards.
Okay.
So his intention, from what he talking to me, was to come into compliance.
Is there anyone else from the county who wishes to be heard on this?
Joining Cotulla Land Development, this is a CLR, Coastal and Lakes Residential, and does not allow for mobile homes, and it should be otherwise vacant.
Okay.
Or recreational vehicle storage.
Well,
I'm sorry?
Or recreational
Oh.
vehicle storage.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it is a respondent's responsibility to contact the Code Compliance Division when the violation has abated in order to allow for reinspection.
How much per day?
50.
Okay. I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of Homosassa Preserve Llc. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Thanks.
The next case, Trent and Mary Marr, case number 215-5732. Code Officers J.C. Charlton, page 22 of your agenda. Ms. Joanna Cattoux is the expert.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And can you please state your name for the record?
Mary Marr.
Thank you.
Good morning.
Can you hear me?
You can move that if it's
Okay.
better for you.
Better?
J.C. Charlton, Citrus County Code Compliance Officer. Case number 215-5732, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 823 North Appalachian Terrace, Crystal River, Florida. Property owner Trent and Mary N. Marr. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be entered into evidence. Exhibit A, photos taken during my initial inspection on December 9th and corrective action inspection on December 28th of 2021, and photos of my final inspection on March 15th, 2022. Exhibit B, a copy of the notice of violation, notice of hearing, a copy of the continuance letter notifying the property owners of today's hearing, photos of the posted property, and a copy of the posting affidavit I completed, as well as a copy of the property appraiser's summary listing the property as vacant.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you object to them being evidence in this hearing. And take your time. Ma'am, do you have any objection to those being exhibits in this case?
I do not.
Okay,
I also have exhibits.
great. Is there anyone from the public who wishes to be heard on this case? And I'll give you a chance to present those. I usually, by policy, I let the county present its case first and then go to the respondent.
Very good.
But maybe that's the wrong procedure. If I wrote a book of all the things that I should have done, it would be called an autobiography. I'll be here for the next hour. Okay, without objection, what's been proposed as exhibits A and B are evidence?
I conducted my initial inspection on December 9th, 2021. I observed boat trailers, tractors, and other equipment on the vacant properties on Coastal Lakes Residential. I've had no contact with the owners. As of my final inspection on March 15th of 2022, the property remains in violation.
Is there anyone else from the county who wishes to testify?
Yes.
Joanna Cotulian Development. This is a Coastal Lakes residential, not mobile home site, should be otherwise vacant. Now, they have applied for a primary structure permit. They applied in 2021. It has not yet been approved or issued. It's my understanding they are, it was denied by the building division, and they want to contest that. There is a process to go through that has not yet been initiated to my knowledge. So there is stuff stored there, unfortunately, before a permit was issued or a primary structure established.
Why was it denied?
It was denied by the building division by site review, and I haven't had the facts presented to me at this time.
Let me just take a moment to look through this, and then Ms. Marr, I want to hear from you. Just give me 1 second. Okay, Ms. Marr, what's going on?
Okay, first of all, you probably don't recall, but I did speak with you on the phone regarding this issue. And prior to that, we have hired Lisa Wilson, the permit tech, to help us with our application. And she also had spoken to you.
That was the only person I spoke with. I've never talked to you on the phone.
All right, maybe I talked to a different inspector. I thought it was you. Anyway, I spoke to somebody as well as our representative, Lisa Wilson, did speak to them. So we haven't not made contact with them regarding this issue. As far as my exhibits, I don't know if you want to do those yet or not. But a couple things to clarify. We are working on the permit. We have been in contact with multiple people, have asked multiple times for a written explanation of our denial. From what I understand that they've told me thus far is there is no, they're saying we have to have 51% living area in our structure we're trying to build. And there's no numerical definition in the code whatsoever as far as the size of the living area, what it has to be. So there is issues, and we are working with them, and we are working involving Mr. Stillwell to help us as well. So we're not participating with them. I have a zillion emails going and everything else. And I actually left a message for Miss Joanna yesterday. She was out sick. So as far as the storage itself, the exhibits are of 11 different photos within our side of the river of lots with trailers parked on them. So when we purchased the
You're-
lot.
Let me make sure I understand. Actually, if we don't, do you have a copy of those exhibits, or do you just have one?
Yeah, no, they're just.
Is that the only one you have?
Yeah, you can take it. I don't need them.
Okay. Let's have the county take a look at
Okay.
it, and then we'll introduce them as evidence if the county has no valid objection. And it's your testimony that what these purport to show is other lots with trailers on them?
Yes, which we
Not
ha-
yours.
Correct. And we have removed all of the trailers
Let
except
me make sure I understand.
Okay.
How does that help your case if
To-
other people are violating?
why we did it originally.
I see, okay.
So we removed them after. The only thing left on there is our tractor and the trailer with the implements on it that we
Okay.
wanted to use for the site.
Yeah, I see three
The-
things.
So the very last picture as of yesterday would have been just our tractor with the implements
Yeah, I see a
for
trailer.
that we were hoping to use
Okay.
for the site itself for construction.
Unless somebody can establish what the classification is on each of these properties.
Well,
And I see some of the trailers are actually in road right-of-way.
I think
so-
she's using it for evidence of intent, that because other people had implements on their property, that they assumed, in other words, it wasn't meant to be a flagrant violation of the code, it was unintentional. Am I wrong? Is that what you're?
That is correct.
Okay, I'm going to overrule the objection and accept it for the purpose of showing what the intent was. And this will be Respondent's Exhibit A. Well, Ms. Marr, the issue with some of what you're saying is that the county, I don't know the code sections on what the amount of living space, or it's not before me. But I do know that there's often quite a bit of discretion when a site plan review is performed. In other words, sometimes site plans can be approved with conditions. And if the county has a condition, and that's a condition, you might be able to challenge it, you might not, but that's really not before me. So my question to you is, and it sounds as though there's a procedure or a method to contest whatever the denial was and the basis for the denial, but that those procedures haven't been followed, is what the county testified to. I understand you have concerns, you don't think it's valid, but it sounds like you may need to investigate some kind of a formal appeal. I don't know, and I'm not your lawyer, so I'm not going to give you legal advice. What's before me today is the fact that, really this is a very slight violation, but the code doesn't distinguish between slight and major unless there's a sanitary issue. So really it's uncontested that technically there's a violation. Even if the permit was going through the process, this is still a violation because it has to remain vacant until you're ready to go, unless I'm wrong, if the county's telling me. Okay. So I guess what I want to know from you is how much time would you need to fix this issue?
30 days, 2 weeks, but 30 days more than enough. We have contacted somebody about renting space commercially to store it if we need to, and they did say that is available. So we're hoping not to, but we're ready to do it if that's what's required.
You'll have 30 days. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondents' actions relative to this violation. We would also ask that it's the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
I am going to find that the property is in violation. I'm going to grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, within that time period, a fine of $50 per day will accrue on the Marr family, the owners of the property. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record. And I encourage you, if you do bring the property in compliance, please contact the county and let them know.
And is there a specific department to contact for that?
Yes, ma'am.
Okay.
All right.
Okay,
Thank you.
Thank you.
The next case, Jane Ellen Patterson, Michael Arlen Patterson, case number 2157963, Code Officer Amy Becker, page 24 of your agenda.
Morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Sir, can you please state your name?
My name is Kobe Edward Kuhn.
Good morning.
Good morning.
Amy Becker, Code Compliance Officer. This is case number 2157963, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 63 South Davis Street, Beverly Hills, Florida. The property owner is Jane Ellen Patterson and Michael Arlen Patterson. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on January 28th, 2022. Photos taken on February 4th showing the posting of the property, and photos taken on my final inspection on March 15th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt, signed for on February 16th.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
Can we ask the relationship? Because he's not listed as one of the owners.
I'm sorry, sir, what's your name?
My name is Kobe Edward Kuhn.
And what is your relationship?
The granddaughter of Miss Jane is my girlfriend who lives on that property, and I just recently moved onto that property because we had a child together. I have no problem with all of that. It's all accurate. The issue is that I did not agree.
Sir, if you don't mind, I want the Assistant County Attorney to be able to hear what you say, and she's reviewing.
Okay.
If you just give me a second.
Mr. Kuhn,
Yes.
can you spell your first name?
It is K-O-B-I.
Thank you.
And last name is spelled with a K also.
Oh, thank you.
So I guess the first issue is whether he can speak on behalf of the owner.
Well, let me know what you think. I mean, I think he's represented that he resides on the property, and normally that confers standing to.
It could be a violator.
The two owners, one of them is in a nursing home in state custody. The other one is not mentally or physically capable.
Tell me which one is which.
The grandfather I don't know very well. He's
Michael
in the nursing
Arlen.
home. The grandmother I do know pretty well. She lives with Rachel's mother, and I forget the name of it. It's an hour and 10 minutes from here. She takes care of her mother because she's not physically or mentally capable to do so.
But you had represented that Michael Patterson is incarcerated? I'm sorry, who's in?
No. Well, there's two Michaels. One's a grandfather and one's the grandson. I'm not sure which one's on that property.
The grandfather, I think?
The grandfather is in the nursing home.
Nursing home?
Yes.
Okay. Before I let you, I think we've agreed that, well, I've determined you have standing to speak today. So I want to hear what the county has to say first, and then I'll get to you. Is that okay? Please proceed, Ms. Becker.
Okay. On January 28th, I conducted my initial inspection for accumulation of junk and debris and observed discarded furniture, carpet, and other debris, which is a clear violation of the ordinance listed above. As of my final inspection on March 15th, the property remains in violation, and I have had contact with Kobe, and I have had contact with Nancy Morris, and they're aware of the violation.
Just for the record, without objection, what's been proposed as Exhibits A and B are evidence. Let me just look through this, and then I'll ask you, Kobe, some questions. And what's your last name, Kuhn?
Kuhn.
So, Ms. Becker, unless I'm mistaken, it looks like has there been improvement?
There's been improvement in the front. The back is where there hasn't been improvement. So there's an old sofa that's actually disintegrating, and there's some bags of trash in the back.
Okay.
And then in the front, there's the carpet and a little bit of trash in the front.
All right, Mr. Kuhn, what's going on?
So when Rachel and I had a child together in December,
Congratulations.
I did not agree with the way that Rachel or any single living member of her family lived. I did not want my child in that house. So I moved out of my house and moved into that house, and I've been getting rid of everything that's damaged, old, anything like that. I've been doing a little remodeling in the house, trying to get things in order because my child is living in that house.
Well, the undisputed testimony is that there's been some improvement, but it looks like there's still, I mean, and I agree, it doesn't look too good in the back. So
Yes.
what's the plan in the backyard?
I'm gonna get all of it done, the entire property, the inside and out. It's gonna be a major improvement, but I'm the only person with a driver's license. I don't have a truck. I'm the only person working. I'm supporting 4 children and my girlfriend by myself. So the time and the money are an issue. It's not like I can immediately get this done.
Well, what kind of money do you need to clean the backyard?
I need a truck, a trailer, pay dump fees, and I don't have a truck. I have to pay to borrow a truck, which
Okay.
I've done so multiple times already to take a lot of the things to the dump.
Okay. Well, the interior is not before us. I encourage you, of course, to obtain any permits you need for the work that you're doing. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per day, along with administrative costs, to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners. Once they were advised of the violation, this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Mr. Kuhn, I don't think y'all are that far off. So I'm going to find that the property is in violation, but grant you 2 months to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded on a constant lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. Property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as lien of record. So one of the things here is that even though you guys are not technically the owners, if the county does put a lien on the property, it means they could end up foreclosing on the property to obtain the money from that lien.
Right.
So, you know, it does affect you guys if the county decided to go that route. All right, that's it.
All right, the next case, Tammy Smale, case number 215-3436, Code Officers George Pearson, page 26 of your agenda.
Good morning. What page?
26.
26.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
My name is Thomas Smale.
Thank you.
Good morning, George.
Morning. You ready?
I am.
My name is George Pearson. I'm a Citrus County Code Compliance Officer. The case number is 215-3436. Violation is junkyard conditions. A violation of Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. The address is 1651 South Shady Terrace, Inverness, Florida 34450. The property owner is Tammy Smells. Service was good by signed certified mail receipt. I'd like to authenticate and request the following be entered into evidence. Photographs that I took on October 28, 2021. Photographs depict the violation of junkyard conditions. Exhibit B, copies of notice of violation, notice of hearing, and signed certified mail receipt. Exhibit C, photographs that I took on March 15, 2022. The photographs depict the property still to be in violation of junkyard conditions.
So, sir, I'm going to ask you to take a look at what he's proposed as the exhibits and let me know if you have any objections to them.
This is the date I initially took them. You can look through them.
Yeah, you've been working with me, so I mean, it's very well. As you know, it's gotten very much.
Those are just some legal documents there, and those are yesterday.
Okay. And that's pretty much, that's about the only issue that you have with the, okay. That can be corrected very soon.
Sir, do you have any objections to those documents being evidence?
No, Mr. George has actually been working with me
Thank you.
quite a bit, like the last gentleman, transportation, stuff like that is an issue, but.
Mr. Smale, I just want,
Yeah,
I
I'm
need her
sorry.
to be up. That's okay. And what I'll do is I'll look at these photos first, let him finish, and then I'll let you present. Is that, is there anyone from the public who's going to want to be heard on this case? All right, then without objection, what's been proposed as exhibits A, B, and C are evidence. Mr. Pearson?
I conducted an inspection on October 28, 2021. I observed a violation of junkyard conditions. The front yard was filled with appliances, miscellaneous junk and debris. A notice of violation was issued on December 15, 2021. A notice of hearing was issued on February the 3rd, 2022. A final inspection was conducted on March 15th, and the violation of junkyard conditions still exists.
I mean, it looks to me like there's been a lot of improvement from the beginning. Is that fair or unfair?
No, that's fair, sir.
Okay. From your perspective, what still needs to be done?
In the final photographs that I took yesterday, all that stuff needs to be disposed of.
So it looks like there's a couple appliances, although the grill probably does belong.
No, not the grill.
Okay. So I mean, what is it? Can you show me on
The appliances and I can show you.
Sorry, I don't mean to make you. I'm just for the record. So.
And he's storing things in the back that you can see through this tile that is shown over there. That need to be some. If he's going to store things and shield it from view, it needs to be things like that, things like this.
For the record, you're pointing to page C2 and pointed to a discarded appliance and what looks like an old dresser or file cabinet.
Or a file cabinet, right. He knows exactly what they are because you know.
Well, I just have to make findings.
And I was told
Mr.
by
Pearson, you might want to. I'm satisfied.
I'm
if you,
sorry.
I just want you to be able to get picked up on the mics.
You're right.
It's rare, but every now and then. I want to make it clear for the record. That's all. So you've identified those things, and now I want to talk to Mr. Smale about it. So there's a big difference between October and yesterday.
Yes, there's been a lot of, but like the last gentleman, I don't have transportation, and there was somebody that I was going to pay to come and do a dump run for me, but I don't have income. My fiance is disabled and she receives income. Social Security messed up her check this month and she had to recertify, and that hasn't come in yet. But as soon as that does, she's gonna hire somebody to come in and take off all the junk. I just, with the weather and the little bit of work that I do have on the side, which pays my electric and puts food in the house, pretty much that's all that I can afford to do. Between that and the weather the last week, it's just been, I haven't been able to move stuff to where it's out of sight and not eyesore for everybody.
I don't know if the weather is going to get better. Is
Well,
one issue.
come, pardon my language, come hell or high water, it's got to be done.
Right.
Whenever I took over the property, when my brother, who was in possession of the property, which was why it was so bad, he became incarcerated. I took over the property, and between her being in the hospital, going back and forth in the hospital, and her mother being disabled, which now isn't there right now. It's been real tough for me.
No, I accept that.
It's
I'm
only
not.
me, and
But
the
let me ask you.
vehicle is actually the vehicle's not mine.
Let me ask you a question. So, I'm curious. How much does a dump run cost?
It goes by weight. It depends on the amount of stuff, but again, transportation is an issue. The truck isn't mine. It's not even legal right now. It's I have roommates and they have helped me do some of the work, but they've pretty much quit doing anything since they got the vehicle.
Well, we only encourage legal remedies here at the code compliance. So I encourage the use of legal vehicles.
Yeah,
but
exactly.
how much time do you think you will need? To...
I think that I can have it done in 30 days. George has been working with me. He has given me a good amount of time.
I agree.
But extenuating circumstances have prevented me from getting it 100%. I'm almost there.
I agree. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. The amount was selected based on the actions of the property owner once they were advised of the violation. The amount is appropriate given the severity of the violation and respondents' actions relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the action has been abated in order to allow for reinspection.
I do so find. I also adopt the county's proposed findings of fact. The property is found to be in violation. Property owner shall be granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a fine of $100 per day will be imposed.
Well, from what date would that be?
From the date that the county determines you haven't brought it into compliance. So I've given you 2 months.
Okay.
So that fine won't begin to accrue if you fix it within 2 months.
Okay.
But what the county will do is they'll check, after that time has elapsed, and they'll give me an affidavit, and then I'll sign an order saying, here's the fine, right? The fine will be recorded and will constitute a lien on the real or personal property of the owners, and the county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
Very
Thank
much.
you, George.
Okay, you're welcome.
The next case, Gregory S. Schweigert, case number 2130762, Code Officers Matt Hampton, page 25 of your agenda.
Good morning.
Mr. Sawyer, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
So
I
help
do.
you God.
Absolutely. Thank
And please state your name for the record.
you. Gregory Sweater.
Thank you.
Good morning again.
Good morning.
Matt Hampton, Citrus County Code Compliance Officer. It's case number 2130762, abandoned, unserviceable, and unlicensed vehicles, violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 9810 South York Way, Homosassa, Florida. Property owner Gregory S. Schweigert. Good service on the property via signed certified mail return receipt. I would like to authenticate the documents and request that they be admitted into evidence. Exhibit A is photos I took during my initial inspection, January 5th, 2021. Photos I took during subsequent inspections, December 6th, 2021, and January 13th, 2022. Photos I took for the corrective action inspection, February 16th, 2022, and photos I took on March 14th, 2022, as well as photos I took during my final inspection on March 15th, 2022. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail return receipt signed for by Greg Schweigert on February 24th, 2022 at 3:17 p.m., and a copy of the trailer registration provided by the property owner.
Mr. Schweiger, I'd like to ask you to look at what's been proposed as Exhibits A and B and let me know if you have any objections to those being evidence. You have no objection?
No objection. That's what was recently done.
That's the notice of violation.
That's the one I signed for last week, right?
Is there anyone from the public who is going to want to be heard on this case? Okay. What's been proposed as Exhibits A and B are now evidence.
I conducted my initial inspection on January 5th, 2021, and I observed the property to be in violation of the ordinance listed above. There was a vehicle and a trailer that were untagged and or unserviceable on the property. There was a long gap between inspections, and I re-inspected as if it was a new complaint on December 6, 2021, and I observed no change of the property since my previous inspection. I spoke to Mr. Schweigert on December 16, 2021, and had advised him of the violations for the vehicles, and at the time there was a grass violation as well. He said he understood and would work at getting the violations taken care of. I did a follow-up inspection January 13, 2022, and had observed that the lawn violation had been addressed, but the vehicles remained untagged and inoperable. I issued the notice of violation January 13, 2022, and I conducted a corrective action inspection on February 16, 2022. There was no progress. Notice of hearing issued was February 16, 2022. I received a signed certified mail return receipt back for signed for Mr. Schweigert. I received a message from Mr. Schweigert that the car had been removed. I received a message on March 14th that the vehicle had been removed, but the trailer had remained, and also that the trailer had a registration at the time. Before contacting Mr. Schweigert back on the 14th, I did conduct an inspection to just verify and also to see if there was any, if there were any discrepancies, I could advise him at the time of my call back to him. And like I said, I did notice that the vehicle had been removed. However, the trailer did not have a tag on the 14th when I inspected. I had contacted Mr. Schweigert on the 14th when I got back to the office and had a conversation with him and thanked him for removing the vehicle, but advised him that the plate was not on there and that he'd have to provide proof of the plate, and also advised him at that time that the tires were still flat and needed to be addressed as well, because it makes the trailer unserviceable or inoperable, excuse me. During that conversation, he did become a bit argumentative with me. I ended up having to end the phone call with him, and he did, on the 15th, or on the March 15th, I did conduct a final inspection, and the plate had been put on at that time. However, the tires were still flat and unserviceable, and at the time I returned to the office, there was a copy of the registration that was put in our mailbox that was forwarded to me, that I believe Mr. Schweigert had dropped off at the front desk to show that the trailer was properly tagged. The trailer does remain on the property though. However, it does have a tag. However, the flat tires still make it inoperable and in violation.
What's going on, Mr. Schweigert?
First, I'd like to apologize to Mr. Hampton for my candor. I didn't realize that this was carried over from a year ago. I thought that I had come into compliance last year. I had gotten a tag for the trailer. The trailer has bubble home tires, which are not now legal to be pulled. The trailer must have, it's a concession trailer, quite heavy, and now must have new axles. All right, I tried to fill the tires, but I did put the tag on it, and it was quite confusing to me because of the difference. I didn't know we were carrying two things into one. I've had a structure burned down next to that, and then I've had to raise another one within the county's means at this time. I was confused. Mr. Hampton's been nothing but kind to me. All right, I'm in violation, as he says. I'm waiting to get axles just so I can get it to move. I mean, it's meant to be that, but I thought keeping the tag on it would satisfy the needs. And again, I apologize for my candor with Mr. Hampton.
Mr. Hampton, let me ask you about this notice of violation.
Yes, sir.
Was this the original notice of violation that was issued in this case?
Yes,
There's only been one notice of
correct.
violation? Because it says on it, on January 5th, 2021.
Yes.
The property, da-da-da, and I see the photos, but it's dated January 13th, 2022.
Yes. I had, just to be completely, I had a rough year of work last year
Yeah.
with a bunch of different things, as most people do, and I had fallen behind on numerous cases, but I've been working diligently to try to do that, and anytime I've, by much, fault of my own, that I mess up on a case, when I get, if I lose track of it, I start it refresh back from the beginning, because I don't want them to be,
And I had to ask why it hadn't been posted. Well, it had been the year prior. I didn't know this was the same thing. I thought this was a new case opened, and there was a lack of understanding. And,
Well,
I've had COVID twice in the last 2 years, I suffer with blood clot disorder and been hospitalized for that as well. I can't work like I'd like
Well,
to.
you've both testified to the fact that progress has been made, and I was just curious to know the timeline for the purposes of dealing with the trailer. So that makes sense, Mr. Hampton. And it looks, so the only thing that really needs to be done is to find a way to make this thing operable.
either remove the he has two options,
Right.
either remove it, obviously, or replace the axles to where it is,
And I'm waiting to get axles.
How much time do you need to do that?
I would hope 2 to 3 months. I've been waiting 2 months at this point in time. You
Really?
know, Yes. The back order, it's quite heavy, and 10,000-pound axles, I guess, just aren't on the shelf.
Okay. Well, you've paid the money to get it licensed. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as a respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I am going to find the property to be in violation. I'm going to grant 90 days from today to abate the violation based on Mr. Schweigert's representations. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and will constitute lien on the real or personal property of the owner. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thank you.
Thank you.
The next case, Rodney R. Blake, case number 215-5852, Code Officer J.C. Charlton, page 5 of your agenda.
Good morning. I'm Amy Blake. I'm needing to appear for Rodney.
Let me just swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I'm sorry, what's your name?
My name is Amy, middle initial J. Blake.
Okay, thank you.
Morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 215-5852, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 2031A of the Citrus County Code of Ordinances. The address is 7488 West Cowhide Cove Path, Crystal River, Florida. The property owner, Rodney R. Blake. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on December 15th of 2021. Corrective action inspection on February 10th, 2022. A follow-up inspection on February 24th, and my final inspection on March 15th, 2022. Exhibit B, copies of the notice of violation, notice of hearing, photos of the posted property, and a copy of the posting affidavit I completed.
May I examine those, please? Thank you very much.
Yeah, just let me know if you have any objections to them being evidence in this case.
I don't have objections. However, I would point out that no notice was received by the landowner. Just let me look at it real quick. This is the first time I'm seeing the notice of violation.
Are you the owner?
No, I'm not. I am his daughter. Mr. Blake suffered from an ischemic stroke on or about December 14th of 2021. And so I am in charge of sorting out his affairs. So I see that nothing was certified sent to the residents at 824 Southwest Kings Bay Drive. And even if it had been, he has been in cognitive decline in a situation where the caregiver was not providing medical care. So I find myself in the middle of an elder abuse case involving my father.
Do you have a power of attorney?
Unfortunately, I do not. I was expecting him to appear this morning, so you've probably observed me coming in and out of the courtroom attempting to contact him to see if he had a good enough day to get here. We could continue this if you wish for me to get a power of attorney.
Well, let's talk about these exhibits first.
Okay, let's talk about these
just
exhibits.
take your time
We have not, Mr. Blake has not received any of the exhibits except for this February 10th one,
Okay.
which was posted on the property
Right.
in a plastic sleeve.
Yes.
So I can attest as a witness that I personally found this
Right.
on March 1st, and I will have an exhibit for the special master, which is the return on the writ of eviction. So we didn't even have, the owner didn't even have possession or control of this property until March 1st. So this was something that was an eviction case that had been pending for a long time. And the sheriff's department had been trying to contact Mr. Blake, I guess, beginning on or about August 31st. This property is very rural, as you can attest. It is along, the only access is along a utility easement.
Power
There are
lines.
large power lines. So there are large potholes that are filled with water.
Let me make sure. Normally I wouldn't indulge this while we're trying to assess exhibits, but you're saying that the only access is along a utility easement?
Yes, it's located under the power lines, and it's very
Can you
hard
drive
to.
it? I mean,
You can if it's not been heavy rain,
Okay.
because you definitely will not make it
And it's a
out there.
buildable lot?
It's got structures on it somehow.
I never knew
Alright.
it was even existed.
Okay.
back there.
Your Honor, it's got, it requires a four-wheel drive vehicle to get back there.
Well, Ms. Blake, let me cut to the chase, though.
Sure.
I want to hear everything you have to say, but
Okay.
the most important thing at this point is what the objections would be. And normally what that means is if you have a reason to doubt the authenticity of what's represented in the photos, or you have, because commenting on the exhibits
Correct.
is one thing, but I can't even really allow that unless they're admitted.
Okay. The notices we did not receive.
Okay?
I can either confirm or deny that he posted them. He posted them. So, but we did. This is the first time I am seeing a notice of violation because we were not in possession of the property
I
and they
believe
were
that.
posted at the property.
believe that.
So Exhibit A, based on my view of the property on March 1st, this is consistent with the tenant's possessions that were there
Right.
during that time period. So I do not have an objection to admitting that.
Okay.
And then,
Is that Exhibit A? All right, so admitted?
these exhibits B, I have not seen these.
Okay.
So, and I have not seen the witness or the notice of violation. So this was probably something where the tenants were removing them.
I overrule the objection and admit it as an exhibit for the purpose that that is valid commentary as to the owner's responsibility, but it doesn't go towards the authenticity of the documents.
I
In other-
understand.
Okay.
Oh, did I?
And,
Here.
and just for the record, is there anyone from the public who wants to be heard on this case? All right.
So do you wish to have me proceed, or would
Not
you like?
yet.
Okay.
I want to make sure that Ms. Antrim has the ability to look through this. I don't hear any objection from the county. So again, what's been proposed as exhibits A and B are evidence. And what I'll do, Ms. Blake, is I want to hear what the county has to say and then give you an opportunity to say everything that you want to say.
Okay, thank you very much.
All right, cool.
I conducted my initial inspection on December 15th of 2021. I observed discarded household items and debris on the property. On February 24th of 2022, I conducted a follow-up inspection. I was granted access to the property from a tenant. While at the property, I was able to observe a large amount of garbage and debris on the back of the property. I have had no contact with the owners until now, or representative. As of my final inspection on March 15th of 2022, the property remains in violation.
Were you aware that it was a tenant on the property and not that the owner wasn't residing on the property?
I was aware of that on the follow-up inspection on March 24th, February
And by
24th, sorry.
By that point, the writ of possession, I guess, hadn't been issued yet. Are you aware that there's a writ of possession?
No,
that's been issued?
I was
Okay.
not until now.
Ms. Blake, I'd love to hear what you have to say about the situation. But first I want to ask you, so I think I heard you say that your father has good days and bad days. Is that right?
Correct.
So is it fair to say that some days he has capacity and some days he may not have capacity?
Correct. He's of diminished capacity.
Okay. And so you don't have a power of attorney now, but is it possible that you would be obtaining one in the future?
I would be able to. I would be able just to have a power of attorney. He is a retired attorney from Ohio, and I am a retired attorney from Florida. So between the two of us, I could come up with a POA. Honestly, the only reason I'm not prepared with that this morning is that it was my understanding from speaking with him last night that he had planned to attend in person.
Okay.
He is available telephonically to give me or the court, if you didn't want to continue this, permission to speak on his behalf. So I'm just not sure administratively, for your record, how you would like to handle this.
Well, are you asking to continue the hearing?
I'm prepared to proceed on his behalf if the court finds that I am able to. I do have his express permission to present what I have.
What do you think, Ms. Antrim?
Are you currently licensed?
I am not. I am inactive. I'm retired. And I advised him of this. I said, I cannot appear for you as counsel.
Yeah.
I can appear as your daughter and primary caregiver.
You're a former attorney in the state of Florida?
I'm former and
Okay.
former in Oregon.
Wow.
So,
Okay.
and former federal judicial clerk.
Well,
so I'm aware
those
that
are many steps above me.
I'm just aware that you have certain processes you need to go through to preserve your record. And if I need to come back with a POA, that would not be a problem for me.
The most important thing in this kind of a hearing is due process, and that means giving the people with standing the ability to be heard. So the real question is, do you have standing to represent the property owner? And the rules are somewhat relaxed in these types of hearings, but I'm curious to know what the county's position is on this.
Well, the code says they can be represented by an attorney.
Yes.
In the previous case, the person was actually a violator.
Oh,
So
yeah.
had standing
Right.
as a violator.
Right. Can
So
we
I don't-
look at the code where?
She has stated, though, that they didn't have notice of this until recently.
Right.
Would you allow
So
me
I
to?
wouldn't object to a continuance to
Okay.
the next hearing date.
Would you like to admit for the purposes of ruling on the continuance, this writ of possession that the
I'm
owner?
curious, well, is that the,
This is the original.
yeah. If I take it, I take it.
I know, and I
Yeah,
need it to go
so-
back and forth. I could probably run to the,
Okay, what I'm going to do is I'm
front
not going
desk
to
and get a
admit
copy.
it. I will grant a 1-month continuance.
Okay.
It's without objection from the county, based on the fact that we think, that representation may be able to be achieved by the next hearing. I don't hear any testimony from the county that there's an immediate emergency health or sanitary concern. Is that correct?
Well, the
Yes.
people are off the property, right?
When I went back to do my final inspection, no one was at the property and it was gated and secured.
Okay. Then we'll continue this to the next month.
That date will be 4/20/2022.
And I'll send something. I send a written notice.
thank you very much. That would need to be directed to Rodney Blake Jr. at 824 Southwest Kings Bay Drive.
Is that where?
That's on the PA.
Yes.
Okay.
We weren't receiving notices posted at the property because, as you can tell from the photographs, the tenants were relatively numerous, had numerous dogs, and were quite hostile. This was a civil enforcement sheriff's
Well,
eviction.
it's rare, actually, since I've been doing this, no one's ever actually appeared with the writ of possession. Normally, it's always testimony that they can't get the tenants off. So congratulations on getting the writ.
Thank you.
All right, thank you.
Thank you.
Then the next case, Brenda Hefner and Amanda Frock, case number 2157773, Code Officers Amy Becker, page 12 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Can you please state your name?
Amanda Frock.
Thank you.
Amy Becker, Co-Compliance Officer. This is case number 2157773. Accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner was previously adjudicated guilty of the same violation at the same location on June 16, 2021, case 2140813. The violation abated on July 19, 2021. No fines were imposed. The address is 38 Roosevelt Boulevard, Beverly Hills, Florida. The property owner is Brenda Hefner and Amanda Frock. I have good service via posting of the property as well as the Lecanto government building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection and posting of the property on January 25th, 2022, and subsequent inspections on January 28th, February 1st, February 4th, February 8th, February 11th, February 15th, February 18th, February 23rd, February 25th, March 1st, March 4th, March 8th, and photos taken on my final inspection on March 15th, 2022. Exhibit B, a copy of the administrative complaint and a notice of hearing for the repeat violation, and a copy of the posting affidavit. Exhibit C, a copy of the findings of fact and the order acknowledging compliance for the previous violation.
Okay. Ms. Frock, could you take a look at these documents and let me know if you object to anything in them being evidence?
No.
No?
It was a mess.
Okay. Is there anyone from the public who's going to want to be heard on this case? All right. Ms. Antrim, did you ask why there were so many photos? Is that what?
Yes.
Okay. I had the same question.
We
and
go
that's
twice
why.
a week when it's a repeat to see.
Oh, okay.
In other words, if it comes into compliance, then it goes out of compliance, then it comes into compliance, then it goes out of compliance. It's an extended period of time. So a repeat's from the first day that you see it all the way to the hearing date. You have to make sure that it stays in compliance that full time. Because if it goes
Because of
out
the
of
fine,
compliance,
it's a daily
then
fine.
there's fines. So that's, hence that's.
Hmm.
They're dated.
Okay.
It'll be.
All right. Then, without objection, what's been proposed as Exhibits A, B, and C are evidence. And I'll let you proceed, Ms. Becker.
Okay, thank you. So on January 25th, 2022, I conducted my initial inspection for accumulation of junk and debris, and I observed a trailer full of scrap metal and appliance and debris in the back of the home, which is a clear violation of the ordinance. So I'm going to skip around a little and let you ask the questions if you need to. So basically, January 25th to January 31st, the property was in violation. The property came in compliance on February 1st. The property stayed in compliance 24 days to February 24th. On February 25th, I conducted an inspection. The property was in violation. And as of my final inspection on March 15th, the property remains in violation. And I have had contact with Amanda.
All right, give me just a moment to look
How's it
through
in
this.
violation now?
On the 25th, when I conducted my inspection, there was a broken windows in the front. That broken window has been there. As a matter of fact, it's was still there yesterday.
Broken window in the house, like in the home?
On the side. It's on the side of the house, on the left-hand side.
There's no broken window on the side of the house today.
Well, if
Not
first
today,
of all,
but, yeah.
you'll have a chance if you want to cross-examine. But let me take a moment to look through these photos and. I'm curious, Ms. Becker, so from February 1st to, I'm on February 23rd right now. There's a trailer in the backyard and a pallet and other things, and that wasn't a violation?
Well, the pallets she said she was going to use for
Yes.
fencing, and the definition of the fence allows wood. So I didn't find, so she said she wanted to use the pallets for, but that was the start of it, more things
You were
coming.
working with her, I mean, technically, I've seen you guys
Yes,
violate. Okay,
I,
all right. I'm just trying to understand. Okay, so on February 25th, I see the broken window on the side yard.
there's two of them. One's on the
I see
ground.
both of them,
Okay.
and so, Ms. Rock, I'll give you an opportunity to look at this if you haven't seen it.
I remember the window, but I took the glass out and it's not there anymore.
Okay.
It hasn't been there for quite some time, actually.
Okay.
If you look at the last day, yesterday, the 15th, you'll see that window in the trailer in the back.
All right, just give me one moment. Ms. Becker, are there any circumstances under which storing that window on the trailer would be permitted, like if it was tarped or something like that?
The problem is the extended period of time it's been there, and also as far as it's not only the window, there's also almost like a cabinet-like thing on the, are you looking at the last day yesterday?
Not yet.
Okay.
I'm now on the last day.
Okay.
Ms. Frock, I would like to hear from you. So what's going on?
I scrap for money, but I have not, my car is not running the best now, so I did have a truck that's been removed, but when that broke down, I kinda had to slow down on it, so I don't go getting scrap as much anymore. So I just store it in the trailer until I can get enough to put in my car to go. I load my car and take it to the scrapyard. I didn't know that it was a violation for it to be in the trailer. I did not know that. If I would have known that, I wouldn't have kept it there. But the last time that her and I spoke, she said everything was fine, which was on February 1st, and that she would let me know if there was another violation. And I did not know that it was that it went back into violation at all. If I would have known that, I would have taken it back out. I would have fixed it, and I mean, I fixed it within a week, and it was bad.
So I am looking at the photos from February 1st, and there is debris. It looks like discarded tires and other material in the trailer. And Ms. Becker, you did state that the property was in violation, not in violation at that time. So, I mean, it seems reasonable that a property owner would assume that if that was in compliance, that putting other materials into the trailer would also be in compliance.
The items that were in the trailer on February 1st was soffit and fascia, and it was usable items. It was usable items.
Okay. So,
And
okay.
that's why. And I did contact, on February 23rd, I called Amanda to talk to her as far as a violation, because I saw the pallets.
Mm-hmm.
A gentleman answered, we were disconnected. I called back. The phone just rang and rang. On March 8th, I spoke with the gentleman at the property and advised him the property was in violation, and I advised him of the March 16th hearing.
That was my neighbor that you spoke to, though. That was
Okay.
not, that wasn't
okay,
my boyfriend.
Well, and I just want compliance. That's all I want is
I
compliance.
do
That's
too.
That's what I want.
Ms. Becker, so I hear what you're saying. I see the soffit and fascia materials, but are there no discarded tires in there?
The tires have rims, and if there are rims, they're allowed.
Okay. Just so everyone knows, I don't mean to delay things. I just like to check all the definitions and make sure that everything makes sense. So in the definition of junk, it says abandoned property, et cetera, used or unserviceable automobile parts. So I guess that's why, Ms. Becker, you're saying that if it had a rim, it would be usable. But
Correct.
Without that, it fits the definition of junk. Well, Ms. Fark, I mean, how much time? I mean, here's the thing. I mean, because it's a past violation, there's not going to be a time. I am going to find that the property's in violation. And you know, there's good news and bad news. The good news is I saved a bunch of money by switching to Geico for car insurance. The bad news is but the bad news is that, you know, a fine immediately begins to accrue when a violation happens after a past violation. So,
What's the fine?
is it your position that the property is in compliance today?
I thought so.
Okay.
I thought that it had been in compliance since February 1st. And then she said that she spoke to a man, but it wasn't me that she spoke to. And
Let's see.
if I would have known, I would have fixed it. This is a very hefty fine.
So you were on notice on February 1st that it was in compliance.
Yes.
Correct. When I talked to her on February 1st, I told her it was in compliance. I advised her I'd be inspecting the property twice a week until the hearing date of March 16th. And if found in violation, the fees would start again.
And she also said she would let me know if it was in violation again, and she did not.
It's Well, I mean, it sounds like she contacted the phone number that she had. Am I wrong? I mean,
Yes, I called Amanda's number on February 23rd. A gentleman answered. We were disconnected. I called back. The phone just rang and rang. I couldn't leave a message. Then on March 8th, I spoke with the gentleman at the property and advised him of the violation and advised him of the March 16th hearing.
Ms. Frock, at this point, compliance is what's required.
I understand that, and I thought it was in compliance.
What's the county's recommendation?
Well, since it was a repeat, I went back to, in other words, I made it the lowest I could.
Right.
So the Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin on January 25th, 2022 and continue until January 31st, 2022, which is 7 days, which would be $700, and then assess a fine of $150 per day along with administrative costs to begin February 25th through March 15th. That would be 19 days at $2,850, and then a fine of $200 per day from this day forward until the violation is abated. And we would also ask that the special master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated so that we may re-inspect the property. But if you, with your permission, if you want to, we can certainly lower, and if we can certainly go down from 200 to a lower amount. I mean, I just want compliance. If she's going to do junk work, we need to find a shed, just something to store, to keep it clean during the times that she's not going back and forth.
It sounds like you're going to get compliance. From my perspective, I think that the higher fine, under normal circumstances, a graduated fine makes sense.
Right.
Under this circumstance, I actually think it would be the opposite,
Okay.
based on the facts we have. So
Yes.
the initial violation would be the higher fine, but, you know, I mean, I can see that there were attempts to improve the property.
Yes.
And I have no reason to disbelieve Ms. Frock's testimony that she
Yes.
thought it was in compliance.
Yes.
So what I'm going to do is I'm going to find the property in violation. I'm going to assess a fine of $100 per day for the initial 7 days of the violation. And then from February 25th to March 15th, a fine of $50 per day. And from this day forward, it would be $100 a day. Okay?
Yes, sir.
If the violation is not brought into compliance as ordered, like I said, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Ms. Frock, the sooner this gets done, the less the fine will be. Thank you.
Just jump right back up here. The next case, I'm sorry, Carolyn Cooper, Daniel Buck, and Patsy Buck. Case number is 215-6465. Code Officer J.C. Charlton, page 7 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer, case number 215-6465, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 3436 North Holiday Drive, Crystal River, Florida. Property owner Carolyn Cooper, Patsy and Daniel Buck. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos I took during my initial inspection on December 29th, 2021. Corrective action inspection on January 12th of 2022. A follow-up inspection on February 28th, and my final inspection on March 15th of 2022. Copies of the notice of violation, notice of hearing, and photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is none. Without objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection on December 29th of 2021. I observed discarded household items, garbage bags, and debris on the property. While conducting a follow-up inspection on January 12th and February 28th, I observed junk and debris in the back of the property, as well as garbage bags piled up next to the home. I have had no contact with the property owners until late yesterday afternoon. Patsy Buck contacted the office and explained to me that they now have trash service to try to get the garbage removed. As of my final inspection on March 15th of 2022, the garbage and debris remains on the property.
What's the county's recommendation?
Due to the amount of garbage on the property, and this is the second case that I've had on this property and explained the violation with the first case on the property, the Citrus County Code Compliance Division respectfully requests a special master assess a fine of $200 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $200 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
The next case, Robert A. Corbett, case number 2156393, Code Officer Matt Hampton, page 8 of your agenda.
I appeared recently on behalf of someone in front of a code enforcement board that will go unnamed, and I had a whole spiel on behalf of my client who was innocent, and of course he was. And they just, I got about 30 seconds into my spiel, and they just shut me down. They said, "Do you agree with the 180 days that you'll get or not?" And you know, it didn't make me feel very special, I'll be honest. But it's probably the right way to treat attorneys. So at any rate, we don't do that here in Citrus County. We listen to the public. We give them a chance to be heard. But that's my sidetrack tangent for the day. Good morning again.
Morning again. Matt Hampton, Citrus County Code Compliance Officers, case number 2156393. Accumulation of junk and debris in violation of Chapter 20. Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 7058 West of Jackson Lane, Homosassa, Florida. Property owner is Robert A. Corbett. Have good service via signed certified mail return receipt. I would like to authenticate the documents requested they be admitted to evidence. Exhibit A. Excuse me for a second.
God bless you.
No, I just bubble in my ear or something. Thank you. Photos I took during my initial inspection, December 28, 2021. Photos I took for the corrective action inspection, February 3rd, 2022. Photos I took during my final inspection, March 15, 2022. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt, signed for February 9, 2022 at 11:59 a.m.
Is there anyone from the public who wishes to be heard on this case? Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
I conducted my initial inspection December 28, 2021, and observed the property to be in violation of the ordinance listed above. Notice of violation was issued December 29, 2021, and I conducted a corrective action inspection on February 3rd, 2022. There has been little change other than items being moved around. I have had contact with people at the property, but not the owner. They always say they were always working on it. Notice of hearing was issued February 3rd, 2022. And as of my final inspection, March 15, 2022, there's still junk and debris piled on a trailer and other debris around the property.
the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day $100 per day, along with the administrative costs to begin after the date you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally find it as the respondent's responsibility to contact the Code Compliance Division when the violation is abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
The next case, Samuel Esposito, case number 2157082, Code Officers J.C. Charlton, page 9 of your agenda.
J.C. Charlton, Citrus County Code Compliance Officer, case number 2157082, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address, 6605 North Mary Lois Point, Crystal River, Florida. Property owner, Samuel Esposito. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on January 11th, 2022. Corrective action inspection on January 26th, and my final inspection on March 15th, 2022. Exhibit B, a copy of the notice of violation and notice of hearing, and photos of the posted property, and a copy of the posting affidavit I completed.
Is there anyone from the public who wishes to be heard on this?
That horse at the
Without objection, what's been proposed as exhibits A and B are evidence.
On January 11th, 2022, I conducted my initial inspection and observed appliances, discarded items, and debris on the property. I have had no contact with the property owner. However, while posting the property, I was able to make contact with an occupant of the property who stated his name was Gino. He stated that he would remove the debris from the property. As of my final inspection on March 15th of 2022, a lot of good progress was made on the removal of the debris. However, there's still items in violation on the property.
It looks like there were initially other violations on the property, like unlicensed vehicles.
Yes.
Is that abated or?
Yes, sir.
Yep. What did the occupant, I mean, have you had any contact with the occupant in terms of how much time they need to do this work?
No, he just stated yesterday that he'll continue to remove items from the property. Once I advise him, it will go to a hearing.
What's the county's recommendation?
Citrus County Code Compliance Division, respect for request, the special master sets a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We'd also ask the special master find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Does it make any difference to the county if I say 30 or 60 days? I mean, does the county care?
Not to me.
From its perspective and in terms of its ability to go check or to calendar things, it doesn't make a difference.
That's
okay. The property is found to be in violation. The property owner is granted 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. And I'm granting 60 days due to the cooperation that's already occurred.
Thank you.
Yep.
The next case, Donald A. Fitch, Janelle Riley, and Kent C. Johnson. Case number 2158044, Code Officers Amy Becker, page 11 of your agenda.
Amy Becker, Co-Compliance Officer. This is case number 2158044, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. This is a repeat violation. The property owner was previously adjudicated guilty of the same violation at the same location on October 20th, 2021, case 2150392. This violation was abated on December 23rd, 2021. No fines were imposed. The address is 455 South Thompson Avenue, Lecanto, Florida. The property owner is Donald A. Finch, Janelle Riley, and Kent C. Johnson. I have good service via posting of the property as well as the Lecanto government building. I would like to authenticate the following documents and request that they be admitted to evidence. Photos taken during my initial inspection and posting of the property on January 28th, 2022, and subsequent inspections on February 2nd, February 4th, February 9th, February 11th, February 16th, February 18th, February 23rd, February 25th, March 1st, March 4th, March 8th, March 11th, and my final on March 15th. Exhibit B, a copy of the administrative complaint notice of hearing for the repeat violation, and a copy of the posting affidavit. And Exhibit C, findings of fact and the order acknowledging compliance for the previous violation.
Is there anyone from the public who wishes to be heard on this?
Thank you. Oops.
Thank you.
Oops.
Oops.
All right. Without objection, what's been proposed as Exhibits A, B, and C are evidence. It certainly passes the weight test.
On January 28th, 2022, I conducted my initial inspection for accumulation of junk and debris and observed a TV, tire, trash, and discarded furniture, which is a clear violation of the ordinance listed above. On March 4th, I conducted an inspection and the tire and trash were removed. The property was in compliance. As of my final inspection on March 15th, I observed carpet on the right side of the home and a trash container. I have had contact with Janelle Riley, and she's aware of the violation.
This is not an example of, well, in this case, it's not an example of a property that went into compliance and then out. It's just been out since your initial inspection, correct?
No, it came into compliance. It did.
Oh, I'm sorry, I missed that. I apologize.
No, I didn't. I apologize. So January 28th through March 3rd, for 35 days, it was in violation. Mm-hmm. And then on March 4th, the tire and trash were removed and the property came in compliance. So March 4th through March 14th, it was in compliance, 11 days. And when I went out yesterday, there's carpet out there now.
Could you verify the dates that it was out of compliance from your initial inspection? January 28th through March?
January 28th through March 3rd,
Thank you.
35 days,
Thank you.
it was in violation.
So on March 15th, basically the only remaining violation according to the county is the what looks like discarded or used rug that's in the
Correct. Do you
porch
s-
area.
Yes, sir.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $100 per day, along with administrative costs, to begin on January 28th, 2022, and continue until March 3rd, 2022. That would be 35 days at $100, totaling $3,500, and a fine of $200 per day from March 15th forward until the violation is abated.
I'm just
We
looking-
also,
Go ahead.
thank you. We also ask that the Special Master find that it's the respondent's responsibility to notify the Code Compliance Division when the violation has been abated so that we may re-inspect the property.
Was it the same complainant?
As, you mean as the last complaint prior?
Mhm.
I don't know.
Okay.
I can
No,
check.
I'm just curious. Well, the law's the law. I find that the property is in violation and that it has been in violation from the dates of January 28th through March 3rd, for which there will be a $100 per day fine. That the property was in compliance from March 4th to March 14th. That the property was out of compliance again beginning March 15th. That a fine will be assessed of $200 per day beginning March 15th. And for each and every day that the property remains out of violation.
Out of compliance.
I'm sorry, out of compliance, thank you. The fine will be recorded and will constitute a lien on the real or personal property of the owners. County Attorney's Office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
The next case today, Virginia L. Irwin, Betty Joan Wickersham, Carolyn S. O'Neill, James L. Faust, Roger K. Faust, and Mark Faust. Case number 2152183, Code Officer George Pearson, page 14 of your agenda. That should note that there's 2 additional cases on the same. You may want to run them together. Page 14, 15, and 16 of your agenda.
There are 3 violations on this. I'd like to show them all as one. testify all the
That would be
time.
great.
My name is George Pierce. I'm a Citrus County Code Compliance Officer. The case numbers are 215-2183, junkyard conditions, a violation of chapter of Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A. Case number 215-2186, overgrown unkept lawn, a violation of Citrus County Ordinances, Chapter 20, Article 6, Section 20-61. And in case number 215-2187, unlicensed vehicle, Chapter 20, Article 4, Section 20-41. The address of the violations are 8435 East Jefferson Street, Floral City, Florida, 34436. Property owners are Virginia L. Irwin, Betty Joan Wickersham, Carolyn S. O'Neill, James L. Frost, Roger K. Frost, and Mark K. Frost. Posting of the property was completed, as well as posting of the bulletin board dedicated to such postings here at the Lecanto Government Center. I would like to authenticate and request the following be entered into evidence.
And are these exhibits going to be for all three cases, or are you?
No,
you have
I
three
made separate exhibits.
You have
on it.
3 sets of exhibits.
Yes.
Okay.
I took photographs on October the 7th. Photographs depict the violation of junkyard conditions, overgrown unkept lawn, and unlicensed vehicles. Exhibit B, copies of notice of violations, notice of hearing, and affidavit of posting. Exhibit C, I took photographs of on March 15, 2022. Photographs depict the property to still be in violation of junkyard conditions, overgrown unkept lawn, and unlicensed vehicles.
So you have exhibits A, B, and C for each case.
Yes.
All right. Is there anyone from the public who wants to be heard on this case? When I was a freshman in college 21 years ago, I took this class called Amphibious Warfare. I wasn't in ROTC. It was a ROTC class, but it sounded like a great subject, and we read a lot of books about we read Sun Tzu's The Art of War. We read Victory at High Tide about General MacArthur's invasion at Incheon, and man, I loved it. So I spent a lot of time on my final paper. I spent days working on it. I was really inspired by General MacArthur, and this idea of the indirect attack, and you don't do a frontal assault on a well-entrenched position. You go through their points of weakness. Anyways, so I worked for days on this, and it was probably again, I was a freshman, and I thought it was a big deal that I typed a 25-page paper, but then it became a 50-page paper, and it really only had to be 20 to 25 pages. But I walk in with this 50-page paper, and I bound it, I put a nice cover on it, I walked it in to Major Engel, our instructor, and Major Engel put out his hand, I put the report on it, and he goes, "It passes the weight test, A." And I'm like, "Are you going to read it?" No, he wasn't. So that's the weight test. But we don't do the weight test in Citrus County. We read everything. So, all right. Thank you, Mr. Pearson. So I'll look through these as you go.
I conducted an inspection on October 7th, 2021. I observed a violation of junkyard conditions, overgrown unkept lawn, and unlicensed vehicle. Junk and debris was observed at different locations on the property. A violation of overgrown unkept lawn was observed with grass and weeds in excess of 18 inches. And there were 3 vehicles on the property: a truck with an expired license tag, a vehicle that had never been moved since my first inspection that's considered inoperable, and the rear of an RV that I could observe. No contact has been made with the property owners. The home is vacant. A notice of violation was issued on November 17th, 2021. A notice of hearing was issued on February 2nd, 2022. A final inspection was conducted on March 15, 2022, and the violation of junkyard conditions, overgrown, unkept lawn, and unlicensed vehicles still exists.
You've never had any contact with any owners?
No, and you know what's weird is I guess we got a notation. We used to post on the mailbox, but there was nobody living there. But we got a notation from the director, Scott McKinney, saying not to post anymore because he had received a complaint from the postal authorities.
Wow.
And so, but everything was gone. Everything was constantly removed from there.
Why would the postal, I mean, I've never even heard of
It's
that.
because it's supposed.
Because it belongs to them.
Oh,
Yeah,
I
the-
see.
the-
Okay.
anything to a mailbox.
Right. Even though you
Well-
purchased it, it belongs to them.
The feds don't always play nice
Right.
with other authorities. All right, so
Somebody must have complained about it to them.
why do you believe that the property is vacant?
Because there's nobody there, and the complainant said there's never anybody
Okay.
there. And the property looks vacant. I mean, the vehicles are all in the same location constantly.
It looked pretty good in the beginning, and it kind of.
Well, it does, but, you know, there are high spots of grass, 18 inches or higher.
Okay.
And those vehicles, and due to the cold weather and the freeze, some of the freezes we had, you could see where
Did
the
you
grass.
see any cats there?
No, I didn't see any cats, but I think that's one of the reasons the complainant filed a complaint was feral cats.
Really?
Yeah, 'cause she says right there on the, please don't feed the cats, and I think that's what she wrote on the no trespassing sign that was listed that I took a photograph of.
Okay. But you didn't see any there?
No.
All right. So on case number 215-2187, I'll ask for your recommendation after this. I just want to establish for the record. Well, first of all, exhibits A, B, and C are admitted into evidence on all three cases. 215-2187, 215-2186, 215-2183. I find that there is a violation in case 215-2187 for an unlicensed vehicle. I'm now looking at the exhibits for 215-2186, overgrown, unkempt lawn.
The violation's not so much in front because they have been beaten down or, but where I seen them in the rear of the yard, it was primarily high.
I agree. I find a violation in that case. And then in case number 215-2183 for junkyard conditions. So is the junk and debris just the table?
No, it's the table and there, I can't make out what that one white thing is that's sitting in the back, if it's scrap metal or what. And,
Okay, I
there's
see it.
various points of, garbage, not garbage, but, items that were considered junk and debris along the
All right.
porch in the front.
I'll find a violation on that case. What's the county's recommendation?
The Citrus County Code of Compliance respectfully requests that the special master assess a fine of $100 per day per violation, along with administrative costs to begin after the date you deem sufficient to abate these violations. The amount was selected based on the actions of the property owner once they were advised of the violations. The amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. I'm going to grant in each case 30 days from today to abate the violation. And in each case, if the violation is not brought into compliance as ordered, I think a penalty of $50 per day is more appropriate.
That's
just,
fine.
Just based on what it looked like in the beginning of the case until today, and the fact that, in particular on the junk and debris case, it's compared to most of the other cases that we've had today, it's not as bad, but it is a violation. This fine will be recorded and will constitute a lien on the real or personal property of the owners. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you very
Thanks.
All right, the next case, Cheryl Ann Isaman, 215-6543, Code Officers J.C. Charlton, page 17 of your agenda.
That's a really interesting thing. Huh.
J.C. Charlton, Citrus County Code Compliance Officer, case number 215-6543, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 11794 North Riverbend Road, Dunellen, Florida. Property owner Cheryl Ann Isaman.
Isaman?
Good service.
I doubt we've invented anything here today for this person.
Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during my initial inspection on December 20th, 2021, corrective action inspection on January 20th, and a follow-up inspection on March 1st of 2022, and photos of my final inspection on March 15th of 2022.
Is there anyone from the public who wishes to be heard on this case? No is a men? Okay. No one here? Without objection, what's been proposed as exhibits A and B are evidence.
On December 20th, 2021, I conducted my initial inspection. I observed discarded household items, tires, and other debris on the property. I've had contact with the property owner and explained the violation. She stated that she's having an estate sale, and that's why the items are out in the yard like that. As of my final inspection, there's haven't been much change to the property. Only change is the tires. She placed them in the ground. The property remains in violation.
Are the tires?
Yard art?
Yeah, I mean, are they? Is that like a permitted aesthetic thing?
I don't know if they're.
Is that a part of the violation? Now.
I still think so, yes, because they still can hold water. You know.
I'm not going to address that question because I think it's actually interesting, and there's other violations that we can rely on. What is the county's recommendation?
Citrus County Code Compliance Division respectfully request that the special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master additionally fine that it is the respondent's responsibility to contact the Code Compliance Division when this violation has been abated to allow for reinspection.
Ms. Antrim, I'm now concerned about what you said. I'm sorry. I mean, maybe you shouldn't have said it, but now I'm concerned. I mean, are these tires that, if they are in the ground, they're buried into the ground?
Yeah, but I don't know if they drilled them and put holes in them so they don't hold water, or
how would it hold
Hazard.
water?
I
How would it hold water if the bottom part is underground? Well, I guess it would, because it
Still
wouldn't
can't drain
drain.
out.
It wouldn't
Right.
drain. Okay.
It's also polluting.
You can't bury tires.
You can't?
It's against the law.
Oh, I didn't know that. Well, you can't completely bury tires.
Right.
Would they be permitted to do this if it was just, if they cut it in half and stuck it into the ground? This is important because if they bring the property into compliance in every other respect, but they
for
don't
the
move the tires, well,
If it's left to me to interpret the code,
It is.
it's a violation.
it's you and me.
Because it's not a usable item.
Okay, so let's look at the definition. Junk shall mean any abandoned property, construction and demolition debris, litter, waste materials used or unserviceable automobile or machinery parts. I don't see any exceptions,
That's an unserviceable, that's an automobile part.
and yet
Doesn't have the rim.
people do have a First Amendment right to express themselves.
And she's never stated that, hey, this is, what I'm going to do with them, with the tires, so.
And if we do make a finding of that here today, it's a pretty quick remedy for anyone who's got junk that is tires in their yard. If you wanted to do a display like that, would you normally need a permit? Or like a, no? Okay.
Sir, if I can add one thing, a lot of people have said they have classified that as art, and it's not art.
It's hazardous material.
Mr. Pearson doesn't believe that's art. The problem, Mr. Pearson, is that there's a lot of things out there that you and I and other people might not consider art or a valid expression, but it is protected under the First Amendment. Or, what is art? Okay, as a generic, it's getting late, but as a generic issue, art can pretty much be any human expression. It could be the way I drive. Now, most people don't consider it art, but I do. And so it's, unfortunately, I don't want it to be either here or there. I'm going to find that the property is in violation. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriately given to the severity of the violation and respondent's actions relative to this violation. We would also ask the special master to additionally fine that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated to allow for reinspection.
Was that $100?
Yes, sir.
Okay. I find that the property is in violation. I'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. For the purposes of the order, we will find that the tires are a violation, as they are today. This fine will be recorded and will constitute a lien on the real or personal property of Cheryl Ann Isaman. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
Next case, Jim Ray Johnson, case number 215-3591. Code Officers Amy Becker, page 18 and 19 of your agenda. There's another case, 215-3704.
Okay, Amy Becker, Co-Compliance Officer. This is case number 215-3591, accumulation of junk and debris, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 3, Section 20-31A, and also case number 215-3704, excessive growth and accumulation of vegetation, a violation of Citrus County Code of Ordinances, Chapter 20, Article 6, Section 20-61. The address is 48 South Lincoln Avenue, Beverly Hills, Florida. The property owner is Jim Ray Johnson. I have good service via posting of the property as well as the Lecanto Government Building on both cases. I would like to authenticate the following documents and request that they be admitted into evidence for both cases 215-3591 and 215-3704. Exhibit A, photos taken during my initial inspection on November 2nd, 2021. Photos taken on February 24th, 2022, showing the posting of the property, and photos taken on my final inspection on March 15th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Are these the same exhibits for both cases?
Basically, I'll give you 215391.
Okay. Is there anyone from the public who wishes to be heard on either case? Okay.
But I want this included, so I guess I'm going to, in other words, I want this included in the record, so I'll give you this. But yes, they're the same photos, basically. The grass might have a little less photos in it because of the junk.
Okay, well, so they're
I'm gonna
different.
give you the
They're
junk.
different.
Yeah.
They're different. Okay.
You live here?
No.
All right.
This is the junk.
Okay.
And this is the lawn.
Great, thank you. Without objection, what's been proposed as exhibits A and B are evidence in each case.
And first, let me say that Mr. Jim Ray Johnson was here at the start of the hearing, and he was ill, so he left.
Okay.
On November 2nd, 2021, I conducted my initial inspection for accumulation of junk and debris and observed a sink, a fish tank, and other debris, which is a clear violation of the ordinance listed above. And I also observed excessive growth and accumulation of vegetation and observed grass in 18 inches at the property, which is a clear violation of the ordinance. As of my final inspection on March 15th, the property remains in violation for the junkyard conditions as well as the excessive grass. I have had contact with Mr. Johnson, and he's aware of the violation.
I didn't see it so much in the front, but I guess this is the back.
Correct.
Yeah.
He collects things.
Has there
Does
been
he collect
improvement?
art?
Yeah. Has there been improvement?
No. Well, let me change that. In the front, he has trimmed the front that was on the right.
Yeah.
And the front near the driveway on the right.
Yeah, the rain's not helping the situation. For the record, there is a violation in case number 215-3591, junkyard conditions. And there is a violation, case number 215-3704 for overgrown unkempt lawn. What is the county's recommendation?
For case number 215-3591, accumulation of junk and debris, and case 215-3704, excessive growth, the Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $50 per case, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Did Mr. Johnson tell you how much time he needed, or did he chat with you about what he's doing?
He chatted with me. My issue is the two back tents that you see on that photo that have junk in them.
Mm-hmm.
Obviously, he says that he's waiting because it's under warranty and he wants to get new ones. So he's going to replace those tents and put more stuff in it to abate the violation. So, and if he does, he's waiting I guess the warranty process is an extended one as far as getting the new cloth to put on the tent.
Would that abate the violation if he put it in that tent?
No, and I told him, I said, well, that's something that, in other words, if the junk and debris is, if I can't visualize the junk and the debris, then yes, it would abate the violation.
Okay. So as long as they surround it with something in the backyard and it's out of sight, that would abate a junk violation?
Well, my concern is that he's going to bring more in. In other words, I have previous cases on this that abated, so he brings things back. He keeps bringing things back. So this will come back to us because he just collects things and then puts them in tents on his property. So I advised him he needed to remove the junk off the property. But you're asking me hypothetically if he built a privacy fence. I mean,
Well, not really. I guess what I'm talking about is what constitutes abatement under these circumstances. And so,
Shielded from view.
yeah, the term is shielded from view, which says shall mean completely precluding visibility of the nuisance condition from all adjacent properties and roadways by placing the junk debris, subject vehicle, or any other material that constitutes a nuisance in a duly permitted, fully enclosed structure which has solid walls and a roof.
That tent may not match.
I don't think it does under
well, previously
this.
we've allowed that. So
Yeah, I mean, it's interesting because it's
What
a
the
su-
code says
it-
and what has been allowed are two different things. If the code says it has to be a structure with walls, then it has to be a structure.
That's what I'm
with walls.
concerned with. I think that you could argue that a tent is solid, but I don't think you could argue that it has walls, and
Right.
it's not a. It's not a. Let's see, what's the word here? It's not a structure. So, I think that's the key word. It's really not a structure. I want this to be on the record, whether it's someone the owner looking at YouTube or whether it's in the order, understanding what they need to abate. Tents aren't going to do it.
I'll let him know that. I'll contact him and let him know that.
Okay, all right. So I think you gave me the recommendation in both cases.
Yes.
All right, the property is in violation in both cases, and I will grant 60 days from today to abate each violation. For each case, if the property is not brought into compliance as ordered, a fine of $50 per day will be imposed, and that's for each case. This fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owners shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record. Thanks.
Next two cases, Jerry Dale Luttrell, case number 215-1389, 215-1390. Code officer going to be George Pearson, page 20, 21, and 21 of your agenda.
Oh, I did by chance see your driving abilities, and it is artfully.
Yeah, thank you. I mean,
Very artful. I think.
then I'm not the only one who feels that way. It's great to be, if not appreciated, acknowledged.
Yeah.
And
You could drive for NASCAR.
my mom agrees with you, if it's any consolation.
Are you ready?
Yes.
Okay. I got two cases here on the same property. I'm going to testify to both of them at the same time, and they'll have their own individual exhibits, as did the other one.
Good.
My name is George Pearson. I'm a Citrus County Code Compliance Officer. Case number is 215-1389, junkyard conditions of violation of Citrus County Code of Ordinance, Chapter 20, Article 3, Section 20-31A, and 215-1390, overgrown unkept lawn in violation of Citrus County Code of Ordinance, Chapter 20, Article 6, 20-61. Address is 9034 South Timberline Terrace, Inverness, Florida 34452. property owner is Jerry Dale Luntrell. The service was good by posting of the property and of the posting of the bulletin board dedicated to such postings here at the Lacano Center. I would like to authenticate and request the following be entered in evidence. Exhibit A, photographs that I took on September 23rd. Photographs depict the violation of junkyard conditions and overgrown unkept lawn. Exhibit B, copies of notice of violation, notice of hearing, and affidavit of posting. Exhibit C, photographs that I took on March 15th. Photographs depict the property to still be in violation of junkyard conditions and overgrown unkept lawn.
To be clear, these are two sets of exhibits. Okay, that's good. Is there anyone from the public who wishes to be heard?
It looked like mine till I got it repaired recently.
Were you lucky somebody from code didn't tell me?
Oh, I know, I know.
Without objection, what's been proposed as exhibits A, B, and C in each case are admitted as evidence.
I conducted an inspection on September 23rd, 2021. I observed violation of junkyard conditions and overgrown unkept lawn. The carport was filled with household garbage, appliances, and miscellaneous junk and debris. There was also junk and debris of on various locations of the property. I also observed a violation of overgrown unkept lawn with grass and weeds in excess of 18 inches. A notice of violation was issued for each violation on October 27, 2021. A notice of hearing was issued for each violation on January 6, 2022. The home is currently vacant. Attempts to contact the property owner were without success. A final inspection was conducted on March 15, 2022, and the violation of junkyard conditions and overgrown unkept lawn still exist.
Okay. I find a violation in case number 2151389 regarding junkyard conditions. I also find a code violation in case number 2151390 for overgrown unkempt lawn. What is the county's recommendation?
The Citrus County Code of Compliance respectfully requests that a special master assess a fine of $50 per day per violation, along with the administrative costs to begin after the date you deem sufficient to abate these violations. The amount was selected based on the actions of the property owner once they were advised and the violations. The amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
You did say the property was vacant, but I may have missed it. Have you had any contact with the owner?
No.
Okay. The property is found to be in violation in each case. The property owner will be granted 30 days to bring the property into compliance in each case, and for each case where the property does not bring, the owner does not bring the property into compliance within the 30 days, a fine of $50 per day will be assessed afterwards for each day that the property is not in compliance. The county attorney, this fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording, and the property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you, sir.
Okay.
The final case today, Robert L. and Sharon D. Sorrell, Case number 215-8310, Code Officer Amy Becker, page 27 of your agenda.
Amy Becker, Co-Compliance Officer. This is case number 215-8310, abandoned, unserviceable, and unlicensed vehicles, a violation of the Citrus County Code of Ordinances, Chapter 20, Article 4, Section 20-41. The address is 6890 North Preston Point, Citrus Springs, Florida. The property owner is Robert L. Sorrell and Sharon D. Sorrell. I have good service via posting of the property as well as the LaCanto Government Building and a signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on February 2nd, 2022. Photos taken on February 24th at my corrective action inspection. Photos taken on March 4th showing the posting of the property. And photos taken on my final inspection, March 15th. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit, and a copy of the signed certified mail return receipt signed for on February 28th.
Is there anyone from the public who wishes to be heard on this case? My words start slurring a little bit around 11:30 because of the lack of caffeine, and it's really it's something. You're gonna have to.
Get you some coffee?
Well, I'll get some afterwards.
We're back to drinking coffee.
Under dire circumstances, and believe me, it's a dire circumstance. Thank you.
You have a baby, it's allowed.
Well, I've got a trial tomorrow. I've got a trial next week. It's just one of those things. Okay. Without objection, what's been proposed as exhibits A and B are evidence.
On February 2nd, I conducted my initial inspection for abandoned, unserviceable, and unlicensed vehicles and found a Ford SUV with an expired tag and a Chevy van with 2 flat tires on the driver's side, which is a clear violation of the ordinance listed above. As of my final inspection on March 15th, the property remains in violation.
Have you had contact with the owner?
I have had contact with Sharon on February 2nd, February 3rd. February 2nd, I advised her of violation over the phone. February 3rd, I met with her, and on March 10th, I called her and reminded her of the hearing today.
I mean, what was her response?
She doesn't really have a response. She had previous violations for junkyard conditions, which she cleaned up, and she had an illegal dumping as well.
Was that in front of me?
I don't remember.
Okay.
Was it?
I don't think so.
Okay.
So she's been in violation in the past.
I mean, does she contest that there's a violation?
No, she didn't contest it.
Okay. Yeah.
She just, I guess she's busy. I don't have an answer.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the Special Master assess a fine of $100 per day, along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the Special Master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is found to be in violation. The property owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. This fine will be recorded and will constitute a lien on the real or personal property of the owner. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. The property owner shall be responsible to pay all costs required by county ordinance or regulation, which may also be filed as a lien of record.
Thank you.
That was the last case of the day. The time is 12:05. God bless Ukraine. This hearing's adjourned.